Okay, good morning, ladies and gentlemen, and welcome to our latest online seminar on a Wednesday morning, nice and sunny. I hope it is where you are. Today we're going to be talking about Smash and Grab Adjudication payment updates with Richard Silver presenting. Richard is the managing partner of Silver Shemmings Ash. Let me hand over to Richard.
Thank you, Julie. Thank you, Julie. Good morning to you all. As Julie has said, we're going to deal with the issue of Smash and Grab Adjudications. For those of you who don't know, I'm obviously the senior partner of Silver Shemmings Ash Solicitors. I am a panel adjudicator. I'm on the RICS and the CIArb and a few other panels. And of the adjudications that are referred to me to decide, a considerable percentage of them relate to smash and grabs. And I would guess probably as many as 50%. You will also hopefully be aware that my background is in construction, and indeed I'm a chartered surveyor and used to be both a site surveyor, senior surveyor and chief surveyor. When I did work in construction, rather embarrassing to say, but when I submitted applications, they were never agreed by the PQS, and they were never certified as the correct value as per the architect's certificate. Strangely, it seems that whenever I submitted an application for payment, it was always considered to be more than was properly due, and that for some reason, somehow, I had overclaimed. And it's my experience that that is the norm. Most contractors, when submitting application for payment, quite often claim maybe more than they're properly entitled to. But when I was a surveyor, what you applied for didn't necessarily mean that was what you were going to get paid. And one of the major problems that arose is that we often got certified less than we applied for, and we weren't always told how that amount of assessment had been worked out. Now, it wasn't uncommon for the application to be returned to us like a school piece of homework with red lines throughout and amounts put on account. But on occasion, we didn't get anything. And it was very, very difficult to work out exactly what we'd been paid and why. And dare I say it, when we passed payment down the chain to our subcontractors, sometimes we didn't necessarily give the required backup. And I would be the first to accept that sometimes maybe we didn't pay them what they were properly due. And it was this issue concerning both cash flow and clarification that led in part to certain of the provisions in the Construction Act and the payment provisions then put in the scheme. And what we've now got is we've got a situation where the contract provides for the issue of both a payment notice and, if so required, by the paying party, a payless notice. So in any construction contract, there must be somebody who has to issue a payment notice. And that can either be the party being paid, although that's fairly unusual, or the employer, or someone representing the employer, such as an employer's agent, an architect, a CA. And this payment notice must be issued at a certain date, dictated by what the contract says, running from the due date. And to explain that, that's not necessarily different to what the old architect certificate was. It was issued at a certain date. You didn't necessarily get paid by that date because there was always a period of days running from the certificate. But there's a basic situation that the employer or their representative in most contracts are required to issue a payment notice. And within that payment notice, they've got to stipulate what is the amount due and how that amount has been calculated. Fairly simple. So you would put the amount due is £1 million gross value with a breakdown of that £1 million, less previous payments, less retention, gives you an amount due of whatever. And that's what needs to be issued. We then have the opportunity for the paying party so many days before the final date for payment to issue a pay less notice. And as with the payment notice, within the pay less notice, they must set down the amount they assess as due and how that amount is calculated. So in effect, the exact same content as in the payment notice. So the question arises, why the need for two? And the simple reason is that the pay less notice is an opportunity for the employer to pay an amount that is less. And that could be, for example, that the original payment notice was found to be wrong and they want to reduce it down. Or it may be because they want to set off. Such things may be, for example, for defective work or liquidated damages. Now, the problem arises is what happens if the employer or their representative, the CA, doesn't issue a payment notice. And what the Construction Act requires is that the contract provides that the party to be paid is able to issue their payment notice in default where the employer has failed to do so. So if the employer has failed to issue a payment notice, by the date that should have been issued, the following day, the contractor can in effect say, you failed to issue a payment notice. I therefore issue a payment notice, and that payment notice says the value that is due and the amount that has been calculated. However, that is subject to one important caveat. Where the contract provides that the contractor is required to issue an application for payment, and they have issued that application for payment, that automatically will become the payment notice in default. So let's just run through the scenario. The contractor submits a compliant application for payment in accordance with the contract. The employer fails to issue a payment notice. The employer then fails to issue a payless notice. What happens? And that is the very first case we therefore refer to, which is ISG Construction versus Seevic. And this caused a lot of press and, I suggest, concern for the employer. Because what actually happened, as I say, is that the contractor had issued an application. It was a JCT 2011. It was an interim application. It was one of the last interim applications, but it nevertheless was an interim application. The employer failed to issue a payment notice and then failed to issue a payless notice. And as a consequence, the contractor sought payment of their previous application. And they won. And that was despite whether their application was correct on the merits or not. What was basically decided was that the contractor, having issued a compliant application for payment, in that it was issued on time and in the right format, and not whether what they'd applied for was correct, they were entitled to payment of the amount they had applied for. Clearly, the employer was very concerned, and therefore they went to a second adjudication. And what they sought was what was the actual value of the works carried out on its merits. And the court decided they were not allowed to do that, having had in place the first decision to the effect that a valid application had been submitted and that amount became due, absent the issue of either a payment notice or a payless notice. They were not entitled to go to adjudication again to seek the true value of the works. So that caused some major concern. What it effectively meant is that if you don't issue a payment or a payless notice, the contractor will be entitled to the value of the works and you can never dispute it. Which we turn to the next case, which is a case that I was actually involved in, which is one called Harding and Pace. Now, what happened was the employer, which was two people, Pace and Springle, owned a property with a piece of land behind it. And they entered into a contract with a contractor, Harding, to develop that land. And what was being built was two houses, one for the employer and one for the contractor. But unfortunately, to say the very least, they fell out. Now, what initially happened was the contractor went to adjudication and sought a decision that the employer had repudiated the contract, and as a consequence, the contract was terminated. And secondly, that they had submitted an application based upon the termination, and in view that there had been no payment notice or payless notice, they were entitled to the amount they'd applied for. And the court agreed, or rather the adjudicator agreed. Now, what then happened was that the employer was obviously very unhappy, and they phoned up the RICS and asked if they could speak to an adjudicator to obtain some advice. And they were put through to me, and they gave me the background to the dispute. And what I said to them was the only option open to them, as far as I could see, was to run the argument that there was a separate dispute as to the value of the account, and that because the contract had terminated, they had a right to do so. So the employer was happy with that, so I was instructed to commence an adjudication, which I did. Midway through that adjudication, however, the contractor went to court to have the adjudication stayed. And his argument was that we were unable to run this second adjudication, follow the earlier case of ISG. They argued that it was the same dispute and had been decided, that it had been decided that the amount due to the contractor was the amount that they've applied for in the absence of either a payment or a payless notice. And the court, fortunately for my client, didn't agree. They decided that ISG was different because it related to an interim application, whereas the current dispute that I was involved in was the final application because termination had occurred. What they said, however, was that in order to be able to avail themselves of the right to adjudication, my clients had to first pay the amount that was decided as due in the first adjudication, which they did. The adjudicator in the second adjudication was then able to proceed to reach his decision, which he did. However, unfortunately, that decision was found to be unenforceable because of a perceived bias. What had happened, and which I was unaware of, was prior to my involvement, the employer had spoken to the wife of the adjudicator for a period of an hour, and somehow the contractor got a copy of the BT record. He therefore said that the adjudicator in the second adjudication ought not to have accepted the appointment, and the court agreed and found that his decision was unenforceable. So we all went off for a third adjudication. Towards the end of the adjudication, the contractor again was arguing that the adjudicator did not have jurisdiction and raised a number of points, but then also said that the adjudicator had to reach his decision by the end of that day, and because he couldn't, because of the new information the contractor had submitted, he was out of time. The adjudicator ignored that, carried on and completed his decision, and ultimately found for my client, and we all went off to court again. And this time the court decided that the adjudicator had reached his decision in due time and the decision was enforceable. And as a consequence, the contractor was required to repay monies back to the contractor based upon the proper merits of the case. And what you can see, therefore, is from Harding and Pace, there was a slightly different situation to what had happened in ISG. In that in ISG, it was decided you could not go back and assess the previous interim application because it had been decided in the first adjudication. But in Harding and Pace, it was decided that subject to paying the amount, you could revisit the application and establish what the value was due on the merits. And the two were distinguished because in ISG, it was an interim application, but in Harding and Pace, it was the final application. We then move to Galliford. This was one of the last application, but it was still an interim application. And in Galliford, they followed ISG. They distinguished Harding because it was a final application. And they said that only in circumstances where it is a final application can you go back and consider the merits. Where it is an interim application, however, if it has been decided because there has been no issue of payment notice or payless notice, the amount due is found to be the amount of the application, and you cannot have that matter reconsidered. A further point was considered is the issue of the stay of the enforcement, where the party to be paid is insolvent. And the basic position is that in circumstances where you can show that the party to be paid is insolvent, and that it is your intention to go off to litigation to have the matter considered afresh, that the amount of the award in the adjudication may be stayed pending the litigation. In some circumstances, the paying party has to pay that amount into court. In some cases, they don't. It all depends upon the facts. But in Galliford, the basic situation was reaffirmed that if an amount is due because of a failure of a payment and a payless notice, you cannot go on and to reconsider the merits. Which then takes us to Grove. And to be honest, a lot of people were very relieved by the situation in Grove. Coulson, who this came before, was somewhat concerned about the number of smash and grab adjudications that were ongoing because of the decisions in ISG and following in Galliford. And therefore, he went off to consider the whole situation. In Grove, again, it was a JCT 2011. The contractor had submitted what was considered to be a valid application for payment. The employer had issued a payment notice, but it was found that that payment notice was issued out of time. And they had also issued a payless notice. What happened was the contractor went to adjudication, and it was decided that the payless notice as issued was non-compliant. And the reason for that non-compliance was that the payless notice had referred to a previous Excel spreadsheet, which, if I remember correctly, had been issued some time before the payless notice. It was properly referred to, but it was not actually included within the payless notice. And what the adjudicator had decided was because that payless notice was not included, they had not stipulated how the amount due had been calculated, and hence the payless notice was invalid. Because the payless notice was invalid, it had resulted in an effect that there was a smash and grab, and they had sought and had got a decision that they were entitled to the amount they've applied for. When it went to enforcement proceedings, however, the court decided somewhat differently. In the first instance, what they decided was that the payless notice as had been issued was in fact valid. Whilst the Excel spreadsheet had not been included within the notice, it had been properly referred to. And the fact that it was referred to and could be understood was deemed to be sufficient. It was not necessary that the actual method of calculation was included within the notice, provided it was referred to and one could establish what was the balance from another document and how it was calculated. That was seen to be sufficient. Then turning to the issue of whether you can go to an adjudication on the merits, the courts considered this, even though it was not relevant to the dispute, because they'd already decided that the contractor was not entitled to their application. But they wanted to really clarify the position on smash and grabs following the uncertainty in ISG and Galliford when compared with Harding and Pace. And what the court said was that a party can go to a further adjudication on the merits where there has been a prior adjudication on a smash and grab where it has been successful, provided that the amount decided as due in the first adjudication is paid. So let's just clarify this clearly. If a party goes to adjudication on a smash and grab and is successful, provided the employer pays the amount so decided as due, they can thereafter go on the true value on the merits. And the courts explained why they could do this. And they gave a number of reasons. The first reason was that, I'm sorry, I'm just going to go back on one other thing, is they did address the differences between a payment notice and a payless notice. And it had been said in previous cases that the payless notice might not need to be construed quite so rigorously, that there was a degree of greater flexibility with the payless notice when compared with the payment notice. However, Coulson said that that was incorrect and that both should be considered exactly the same, in that both had to say the amount due and both had to say the amount the sum due is calculated. Turning to the reasons why they said you could go on the true merits, they gave a number of reasons. The first was that in a situation of an amount due, the courts previously were entitled to correct a certificate. That was in effect correcting the value of a payment notice. And therefore they felt that that situation should not be changed. The second is that both within the Construction Act and the Scheme for Construction Contracts, one can refer any dispute to adjudication. That's what it says. A party can refer any dispute at any time. And in the true value of an application is a different dispute to the amount decided as due on the failure to issue a notice. This was a different dispute, and the Construction Act and the scheme provide that you can refer any other dispute. So it would be wrong to prevent the employer going for a dispute on the merits. They also looked at the JCT form and how it was worded, and they differentiated between the term the sum due under clause 4.72 and the sum stated as due in the application or in the payment notice under clause 4.9. There was clearly a difference. One is what is the amount properly due on the merits, the sum due, and the other is the sum due following the issue of an application for payment where the employers failed to issue either a payment notice or a payless notice. And they said that was clearly a different dispute, and clearly it was setting a different circumstances as to what was the amount that should be paid to the contractor, and that one did not magically transform into another. They were clearly separate facts. They also pointed out to the fact that where the employer does issue either a valid payment notice or payless notice, the contractor could go off to adjudication and dispute that. And it was therefore very unfair if in the exact same circumstances where the contractor had submitted an application and the employer hadn't responded, the employer was prevented from going to an adjudication. It was seen to be too advantageous to the contractor that they would be paid what they'd applied for where there had been a failure to issue notices, but where there has been no failure, where there had been a failure by the employer, they could not dispute it. The final thing the court said was that it was wrong to distinguish the situation between interim and final applications, and that the law should be exactly the same for both. and that therefore both Galliford and ISG was wrongfully considered. So let's just clarify where we are. So the situation is that where a party makes an application in accordance with the contract and the employer fails to both issue a payment notice or a payless notice, the contractor is entitled to the amount that is applied for. Having received a decision to that effect, and that amount having been paid by the employer is then entitled to go to adjudication based upon the merits of the application in seeking to determine what is the proper amount due based upon the works that have been undertaken. So one needs to consider, therefore, what is a valid application and what is a valid payment or payless notice. Dealing first of all with the payment notice and or the application. Now, the first thing is it must be understood by the recipient that that is what it is. So that raises a number of things. So the first thing is that the application and or the payment notice must be issued at the right time. It must be issued in the right format, depending upon what the contract says. It must state what is the amount due, and it must state how that sum has been calculated. It also has to be understood by the recipient to be an application or a payment notice. So if it says a number of other things on it, like, for example, draft final account, it may be considered that it is not a valid application. Also, where it is issued at completely the wrong date, let's say far, far too early, to the effect the party doesn't think it's an application, again, there may be a challenge to whether it is a compliant application. And what they will do is to look at what a reasonable person would have understood it to be. So it is not simply what is on the title of the letter, but what would one person think it to be, and is it compliant? So there's been circumstances where contractors have submitted an application, but because it's been referred to as a draft final account, it was deemed that maybe it could not be considered as an application because it was not clearly construed. Similarly, where it was issued far, far too early and far earlier than was anticipated for the application, again, it was found to be invalid. There are also circumstances where there has been an application and then another one issued a few days later and yet another one a few days later, and it was decided because they're all issued too close together that there is again uncertainty. What we then need to go is to look at the actual content of the notice. And as I've identified a number of times, the notice needs to say both the amount due and how that amount has been calculated. And that needs two elements, therefore. What one needs to do is to establish what is the amount gross due. Now, let's just say we're on a traditional contract, and under that contract, you will have, let's just say, the original scope of works, you will have your preliminaries, you will have variations, you will have materials on site. And what you should be doing is providing a breakdown to those amounts. So what you may have, for example, in the most simplistic of terms, is the value of the works is measured works is 70% of the B of Q as per the attached, plus the variations as per our variation account, which is another 100,000, plus preliminaries based upon 70% of the works being complete as per the schedule attached, plus materials on site as per the list provided here too, which all comes together to £1 million. That is 1/2 of the calculation. What you then need to do is to establish what that leads to being paid. So it's £1 million less the amounts previously paid, let's just say 600,000, less retention equals the sum due plus VAT equals the total sum due. We need both sums, both calculations, how one comes to the gross amount and how one comes to the net amount. And there's been a number of cases where they've shown that that information has not been provided, and therefore it was considered to be an invalid notice. And do remember, as I pointed out, both the payment notice and the payless notice, as to their content, is likely to be the same. You have to state the sum due and how that sum has been calculated. So where are we? It seems to me that we have got to a final conclusion on this following Grove, to the effect that a party, where they've failed to issue either a payment notice or a payless notice, can at a later date go to a adjudication based upon the amount properly due on the merits. But they must have first paid the amount that was decided due based upon a smash and grab. I think it is important that the contracts as drafted recognise this and allow for these further assessments and repayments to the employer where they've effectively paid too much to the contractor because it's been a smash and grab. But I do find it surprising that there still seems to be a lot of smash and grab adjudications. And I guess it's because it's an easy way to get money. And at the moment, cash flow is very important. So therefore, I do impress upon you, those of you who are paying parties, whether you be the employer paying the contractor or consultants, or the contractor paying subcontractors, consultants, or others. And what you have to ensure is you issue the payment or payless notice. Now, I think one thing to remember is this applies to all construction contracts. And I'm aware that quite often orders or purchase orders are produced and issued to parties for works where I don't think the people knew that they're under a construction contract. And as a consequence, they don't follow these procedures under the Construction Act. And indeed, the contractor's place, the purchase order, does not have compliant provisions with regards to the Construction Act, with effect that the scheme provisions are imported. So I think it is going to continue that there are numerous adjudications on smash and grabs, and there will thereafter be numerous second disputes on the merits. And I am sure and indeed aware of one going to the court at the moment concerning a smash and grab and the issue of a stay of proceedings because of one party being, it is alleged, insolvent. Hope that has been of help. Julie, are there any questions?
Currently, we don't have any questions. So if anyone has got a question, please feel free to pop that into the Q&A tool at the bottom of the toolbar. As always, if you have a specific question that you don't wish to raise in an open forum, please feel free to email Richard directly on richardsilver@silverllp.com. He will be happy to assist as always. So, no, it looks like you've covered everything and everyone is happy and they know everything they need to know about smash and grab adjudications, Richard. So thank you very much, everyone, for attending this morning, and we'll see you all again soon. Thank you, Richard, for your time, as always.
Thank you.